going to ask that the vice chair advise council, as will I, as to our availability next week. So you're aware I am available only on the 27th, the 27th and the 28th.
I'm available those 2 days also.
The 27th and the 28th.
I believe that means the 27th is available for all parties and the board.
Okay, I am also going to direct council to meet and confer and provide a schedule to the board of the remaining witnesses at the end, that they expect to complete by the end of today, with the times that they will take for direct and cross-examination. I know that that may be of concern. I do not, I'm of the opinion that it do not violate due process rights under the Peace Officers' Bill of Rights, because you will be given a fair and full opportunity to provide your evidence. It has been done in courts, I've had trials. We'll tend to focus, all of you, and perhaps the board also. So I asked you to do that, so at least we'll know whether one more day will do it. I want the examination of witnesses in the present, in your final closing arguments and anything else we have to do, be completed by 3 o'clock, so that it will be completed by 3 o'clock Tuesday afternoon, so that the board can go into its public deliberations and provide you with their conclusions. Any questions from the respondents' council?
No, thank you very much. We really do appreciate this.
Any questions from the appellant's council?
It would just be a matter of, your order is for us to confer on the witnesses for today for closing times. I don't know when we would be able to do that, but for future
Well,
days.
over the watch out.
I have
Just
another.
talk to council about, how do you think I think I need to schedule on, and it looked like after Attorney Cronin, we're going to have Lieutenant Bob,
Palpable is here.
or whoever is here, get an estimate, we're going to finish that witness today, or you need an extra hour tomorrow. I want to know when they're going to start, and when they're going to finish. Get ahead, that's really good. Okay? Further from response, council?
Mr. Chair, I think just to facilitate, I know I'm used to working 2 o'clock in a court, and that's a great solution. If we reserve for each witness maybe 10 minutes at the end for board questions, that might help Mr. Sirolic and I plan better. Would that be a sufficient amount?
Well, you consider that the board may pop in every so often and ask some questions in your calculations. So again, don't care how much you give to each side and how much you give to each witness, but just provide that schedule so it ends on Tuesday afternoon at 3 p.m. Vice Chair, anything to add?
Just my comment earlier was not meant to offend. It was simply to illustrate and point out that the redundancy of the testimony to the records we already have is significant. And what I'm looking for is any inconsistency with testimony and records or any new information. And when I hear any witness repeat the same answer for a 5th and 6th time, we're not making best use of our time or of the witness's time. Now, I don't want to circumvent what you need to do, and I'm very respectful of that, but I think we can get it done in a different way.
And the only caveat I would have is that, I guess we are scheduled for this room on Thursday, but the facility may change if this room is not available next Tuesday. I don't think anyone knows that yet. Hopefully, this room will be available. Just everyone be aware of that. Similarly with the audio feed, making sure that people are available, with staff are available. Anything further? Ms. Brown, do you have anything to add?
The room will be available next week except for Thursday.
Okay, so Tuesday will be good, and we can conclude this at 3. Conclude the taking of evidence and argument by 3 o'clock on Tuesday. Mr. Swallow, can we continue your cross-examination?
Yes, for the final topic that I'd like to ask you about. In your report, you analyzed sustained integrity allegations against Scottsdale Police Department employees, correct?
Yes.
And in that case, every one of the reports that you reviewed related to employees' own misconduct, or reporting or failure to report, or false reporting of their own misconduct, not witness failure to report, correct?
Sorry, can you repeat the question?
Sure, so you, in your report, reviewed instances that you said were integrity violations where, and they were sustained, and in each one of those reports, they were situations where somebody had lied about their own misconduct when they were under investigation, correct?
Okay, I'm reading the paragraph, so I just have to refresh my memory. None of the 4 investigations that I reviewed that were provided to me from the city that had a sustained finding, involved a situation where okay, let me rephrase this. We know, okay, so I'm not sure where you're headed. The person who self-reported in this case was Slavin. And I believe in the cases dealing with integrity violations, none of the people that were found to have committed an integrity violation self-reported. Is that what you're asking me?
My question is, in this case, Commander Minor was a witness, and he's alleged to have committed an integrity violation about his statements when he was serving as a witness. Were there any other cases that you reviewed where a witness was sustained or disciplined for an integrity violation based off of their witness statements?
He wasn't a witness in 085. That resulted, 085, he was the target, and that resulted because of something he had not been truthful about. All of the integrity violations that I reviewed were people being investigated because they had said something that that was not truthful.
Okay. And then, for the purposes of determining whether Scottsdale handles situations consistently, in the 2 most recent sustained integrity violations that you reviewed, the employees actually resigned prior to the completion of the investigation, right?
If that's what the information provided to me from Scottsdale says, then that's a yes. I don't have all of the facts memorized. I have them outlined in my investigation.
Okay. Is it your understanding that in spite of their resignation, your summary notes that the integrity violations were still sustained?
It may have been, I don't know. Because I don't know when they resigned. They may have resigned after it was completed.
So you don't recall if they resigned prior to their interview?
I don't think I know that.
That's all I have for now.
Cross-examination.
Mr. Cronin, I'll be brief. Would you agree that as far as the city's historical practices regarding integrity violations or sustained investigations, that the reports themselves would be best evidence of that?
Yes.
The reports contained in City Exhibit 9, all of them, is that correct?
If that's the January 30th letter, then yes.
Okay. Not just the letter, but Exhibit 9 contains all of the reports referred to in the letter.
Okay, I haven't looked at Exhibit 9, but okay, yes. Then
I'll have you turn to Exhibit 9 very quickly, just to clarify. You described a process that sounded like a routine process that is done throughout many kinds of organizations, where a verbal counseling is handled at the supervisor level, and it may or may not fall into employee performance reports or things like that. And then if that supervisor is made aware of a second report, then with progressive discipline, some places choose to elevate that to a written counseling, which will often note this employee was previously verbally counseled.
Right.
Is that general procedure commonplace among organizations that you review?
That I am familiar with, yes, that follow just progressive discipline, yes.
And you review city and state government personnel practices throughout the state of Arizona, do you not?
Well, actually, yes, I do.
I'll just direct you to, very quickly, Bates number page in Exhibit 9003205.
All right, I'm there.
Okay. I'll give you just a second to review that, and then I'll ask you questions.
Okay, I read it.
Does this report document that that is in fact a past practice of the city of Scottsdale?
Yes. It's a letter of counsel.
Okay. It's a written counseling that on its face refers to a previous verbal counseling that was noted by a supervisor, is that right?
That's correct.
Do you, in your entire investigation, do you see any reason to doubt that that same policy or procedure or historical practice was followed in this case with respect to Chief Slavin?
I believe it was followed with regard to Chief
I
Slavin.
apologize, are you talking about investigation 2017-100?
Yes,
Okay, thank you.
and you have this full report.
I was looking at it.
I did not, let me say this. I found that the verbal counseling given to Chief Slavin by, Assistant Chief Slavin by Chief Rodbell, sorry, was consistent with what had been done previously.
And if there are other instances of that being documented in the city's exhibits, specifically Bates number 3196, assuming that it followed the same practice, you agree that would be further evidence of the city's historical practice evenly applied that was used for Chief Slavin?
Yes.
You were asking questions about whether it was appropriate for Chief Rodbell to withhold information and allow the internal affairs investigators to perform a clean slate investigation from scratch. Do you recall that testimony generally?
Yes.
Was it reasonable for Chief Rodbell to assume that the witnesses would answer truthfully and completely?
Yes.
You do not think that it's inappropriate for Chief Rodbell to expect members of the command staff with previous IA experience to know what information the IA would be looking for, would you?
It's not unreasonable, and it's not unreasonable for Chief Rodbell to not only expect, but believe they will answer truthfully and disclose, as a witness, disclose everything that they have relevant to the investigation.
And when you say everything that they have, that includes,
In their knowledge.
would that include subjective feelings or feelings of other people?
I don't think that's necessary. I would expect them at a minimum to disclose factual information.
Is it significant to your opinions that the information that Commander Miner failed to share with IA involved a report by a subordinate that Commander Miner felt significant enough to elevate through his chain of command?
Yes,
So it's not just a feelings situation, it's an employment situation?
it's an employment situation, and it's moved beyond the realm of feelings or subjective, because he has an objective fact that this employee complained to him and said, "I'm upset," whatever he said, but that was the gist of it. And when he reported it to Pop, he said not only was he offended by it, but so was I. Now it's, I mean, those are his feelings that he was offended clearly, but it's now a fact.
You were asked a series of questions by Mr. Minor's attorney. Did any of those questions or your answers, your discussion about those questions cause you to question any of the findings that are contained in the report that we've submitted in evidence?
Not in my report, if that's what you're asking.
And again, just to confirm, have you seen statements from Commander Minor in record that indicate that his desire was to have an independent person review the situation?
Yes.
And you are the independent person who was selected by joint agreement with the city of Commander Minor, is that right?
I believe it was a joint agreement, yes, I guess, yes.
I have no further questions, thank you.
Any questions from the Vice Chair?
Yes, I have a few.
Okay.
And it will just be a few. You mentioned earlier, testified earlier, that you've done 12 to 13 investigations for the city of Scottsdale since 2012. How many of those involved the police department actions?
This is the first one. I had to think because they're co-located with the fire department. I've done two for the fire, so this is the first one.
So to be clear, the Run Bell investigation and conduct was the first time you were pulled into police activity?
Yes, to investigate a matter concerning the police department.
Thanks. Next question. From what I've reviewed with the information that you also had about prior cases, it tells me that AR 333 violations have a range of discipline. And within those things that were summarized in the document January 30th, those cases went from counseling to a letter of counseling to a letter of reprimand to a demotion.
For the AAR 33, yes, I don't recall all, but that sounds about right to me.
In that same document, it stated that every sustained integrity violation resulted in the police department employee leaving the employ of the city of Scottsdale. And in reviewing those, the departure is a result of resignation, retirement, and in the case of Mr. Minor, dismissal.
And I think another one chose to be dismissed, if I recall. Yes, I think there was another person who was dismissed as a result as well. But those were the options, yes.
Yeah, the others look like they decided to take themselves out before the city did, if you will.
Right.
Do you find it in any way inconsistent that violations in AR 333 have a range of discipline? The violations that involve truthfulness or integrity, if you will, only have one result?
I don't, and I can tell you why.
Please.
All right. And I will tell you, allegations regarding truthfulness and integrity apply to prosecutors as well. And the reason being is because so much is at stake based on their integrity when it comes to investigating a crime. A lot of times it involves the officer's testimony, say that I found the bloody glove there. And there's no witnesses to that. Also with a prosecutor, they're seeking justice and their ability, their integrity with regard to disclosure of information and so on. That when you have an employee who commits an integrity violation, it is so severe. And usually the police departments, and there's been some issue recently, you probably heard on the news, but how it's supposed to work is that officers who have committed integrity violations end up on a Brady list. And this is a requirement by the Supreme Court, and there's also an Arizona case. And so a prosecutor, when they have a case, and that officer was involved in the investigation of that crime scene, they have to disclose that they're on a Brady list because they have to disclose all the exculpatory evidence. So it really hinders the police agency or the prosecutorial agency when they have somebody with an integrity violation. It hinders their ability to conduct their job to the best of their abilities. And so that is why every police agency that I'm aware of, and also prosecutorial agencies, including down to paralegals, they take integrity violations so seriously. And the result may seem harsh, but there's a reason for it.
So, when it comes to integrity, there really is no distinction between, and this is a common phrase, little white lies or blatant lies.
I don't know what little white lies are. I mean, let me just be honest here. I mean, I know what you're referring to, and I'm not trying to be. But when it comes to an officer making a misstatement, you don't distinguish. It's either you were truthful or you weren't truthful. It's very black and white because of the ramifications.
Last question. In your investigation of this matter, the chief's behavior, you found nothing that was, quote, wrong.
I didn't find that he acted inappropriately.
Were there any things that you assess could have been done better than what they were?
Yes,
Could you identify what those would be?
just my thought. But you have to remember too, you know, I understand this is the city, they want to work with the unions. I would advise against doing an investigation as a result of that POSA letter because it was so vague and ambiguous. But that's not my decision to make. If I was his counsel, that probably would have been my advice. But I've had many clients not take my advice. And, you know, it's his decision that he gets to make. And the only reason I say that is because there was so little information in the letter from POSA. And it just kind of started off, I used anomaly in my report, and that's what I meant, because usually, and an IA person will tell you this, when they start their investigation, they know the facts pretty much. And they pretty much know the answers to the questions before they ask them. That wasn't the situation here because it, you know, but that has nothing, that's just my opinion, but again, it has nothing to do, let me rephrase it. Chief Rodwell's decision to go ahead and conduct the IA was not wrong. He certainly gets to do that.
Anything else?
I guess the point that I'm trying to make is his decision to conduct that investigation, no matter how odd it started out, which it was kind of odd when you consider internal investigations, in the sense that the complainant was POSA, doesn't excuse the answers that were given by Commander Minor, which is the integrity violation.
No further questions, thank you.
I just have a couple. First, with regard to one of the comparators you used, which on this council asked you about the IA 2017-100 matter. That's where the fellow referenced his head and part of the male anatomy. That was one of the comparisons you used to. First time there was a comment made, there was verbal counseling, and then there was the second time it was a written record of the counseling. Correct?
Yes,
So
is that
actually-
the first one she asked me about?
I believe, I don't know what order, but that was the one I asked.
Right, he had a verbal, then he ended up getting a written.
Well, first, were you considering them, both that individual and Assistant Chief Slavin as similarly situated? Is that term is used in legal sense?
What I was considering, I know what you're referring to.
Well, before you answer, my concern is that under Ellis and Farragut, the assistant chief's got to be considered different than a patrolman, correct?
It depends. Ellerth is a different scenario. Ellerth goes to gender discrimination under Title VII.
I'm talking about the investigation, the responsibility and liability of the employer for actions like those who may have decisions on hiring versus just a regular employee.
No. Title VII is unique in the sense that for violations of Title VII, there's no employee responsibility. The liability, the defendant will always be the employer. There's some exceptions, but just as a general rule. What we're talking about here is how you discipline an employee, not for necessarily Title VII violations, but workplace conduct, which would include unprofessional, inappropriate behavior. And that's where you look, have these employees been treated similarly? Title VII is unique in that supervisors are held to a different standard for a variety of reasons because of the law. So, so in this situation, if a patrol officer made that comment, and then you have Assistant Chief Slavin, we know who made the comment, could they both receive a verbal counseling, and would that be appropriate? Yes.
So you don't see a distinction, at least in Part 2, that between a supervisor and a line employee?
Based on these facts.
What if it was a Part 1 investigation?
That's different, because now we're talking about Title VII.
Now, you also made some comments about, if you have a verbal counseling and make a record of it, then you get a written record. Have you ever heard the term in government, actually, forms that say written record of verbal counseling?
Well,
That's not unique, is it?
it is,
It is?
yes, because I will tell you, in my experience, some places do that. So what that means is you're morphing the two together. They're two distinct, if you have a progressive discipline policy in place, a verbal counseling is what it is. A written counseling is something in writing.
So
If you call it a verbal written, it's a written.
So how do you know that someone's been given a verbal counseling?
You will know if they have further discipline. But if they have no discipline, then you may never know. And usually, I don't know how Scottsdale does it, I'm assuming they do it this way, but usually in the supervisor file, they keep a record that on May 5th, I gave Mary Cronin a verbal counseling. And most places after 5 years, that's considered stale, it doesn't come up. But if I act up within the next couple of months, that verbal will end up in subsequent discipline.
And so, well, I read somewhere that Chief Slavin's, Chief Bell is retiring in a couple months. Say the day before he retires, he gives someone a verbal counseling. He leaves.
Right.
2 months later, that person does something else. How does the city know that they've been verbally counseled?
Hopefully, before he leaves, he's directed, at least this is how I handle it with my clients, they pass on their supervisory files.
So there is a written record that Chief Bell counseled Assistant Chief Slavin. It's in his supervisory file.
It's in a supervisory file, which is not the personnel file, which is different. And I'm assuming he has something similar to that. I don't know. That's a question for him.
Okay. So I have nothing further, followed by respondents' counsel.
Just one question, Ms. Cronin. You mentioned that officers with integrity violations might go on to Brady lists or have some impact on their ability to do their jobs or to be credible witnesses in future court proceedings. I just want to clarify, you've worked with personnel boards in the past?
Yes.
Okay. And you understand that whatever this personnel board decides will have no impact on any type of proceeding, that's a separate hearing process, and that's not the question that anyone is deciding here in this case.
That's correct. That, the process of whether someone ends up on a Brady list is separate and apart from this.
Is that all?
That's all.
Oh, sorry, Mr. Sloan?
Just a few. I'd like to follow up on the vice chair's question about the range of discipline that can happen in certain investigations. And I want to make sure that I understand your position. So if somebody makes an unintentional false statement, they're basically careless, or they say something and it's not well thought out, that doesn't automatically result in termination, correct?
It depends on what the investigation shows, and obviously depends, we're assuming we're talking about police officers or prosecutors,
Right.
prosecutorial agencies. It depends, because I think if you look through some of the integrity investigations, not all of them were sustained. And I'm assuming, I just had, but there something along those lines that didn't rise to the level of an integrity violation.
Well, I guess my question is that if you lied, if you said a false statement because you were careless versus if you lied deliberately, your discipline very possibly could be different.
Carelessness is a tough one, because I've seen where employees have claimed, they've tried to claim they were careless, but it's pretty black and white that they were not truthful. And, they've been terminated. And so, it depends on the facts of the case. And was this person truly dishonest? Did they truly not disclose facts that they had within their knowledge that was pertinent to the investigation?
So let's talk about police reports. If a police officer writes a police report and they leave out a material fact and they said, well, I did it because I, put what I thought was important in there, I put what I thought the victim told me, but I realized I left some stuff out later on. That wouldn't necessarily result in the police officer being fired every time.
Because it's not part of an internal investigation. Internal affairs investigation, you have to be truthful. If you're not, the result is you will most likely be terminated.
And
I've never seen it any other way.
Okay. Being on the Brady list doesn't prohibit you from being a police officer, correct?
Doesn't prohibit you, but it really curtails your ability, because that has to be disclosed to the opposing side. And it certainly hinders, because obviously your ability to testify as to certain evidence or where the evidence was found, I'm just talking, is hindered because you have now been found to be untruthful.
Well,
And defense counsel will have a good time with that.
yeah, it's a disclosure requirement, right?
It's a disclosure requirement, and it's also admissible.
Oh, it's your understanding, and you're here testifying under oath, that if you're on the Brady list, that's automatically admissible in court, in criminal proceedings?
Depending on the relevancy to it, the judge has the discretion, but yes, the defense counsel will argue, because it goes to the credibility of the witness testifying.
But it's not your testimony, then as a matter of law, that's admissible,
I'm not
right?
saying it's automatic, it's always subject to discretion, and it's always subject to the relevancy and the facts of the case. You could be, directing traffic and you're on a Brady list, maybe it's not relevant. So it depends. So it's always subject to discretion, but defense counsel will try and get it admitted.
And you don't know what percentage of the time it actually ends up admitted in court, though, do you?
I don't, because I don't study criminal cases looking for that information.
Right. So you gave some testimony about the possible existence of this supervisory file related to Chief Slavin and Chief Rodbell's documentation of that. Did you ever see that supervisory file?
I am not saying he had one. I said I didn't know. I'm opining as to how it usually occurs. And I also said, with regard to the documents that Chief Rodbell kept, that's what he needs to answer to. I'm just telling you, based on my experience of being an employment lawyer for 30 plus years, that is how it's documented. And a supervisory file is very different from a personnel file.
The supervisory file in Arizona is, though, subject to public records disclosure, right?
Maybe or may not be. It's not automatic.
You think that it's not subject to disclosure?
I said it may or may not be, it's not automatic. The personnel file with redactions can be, but not necessarily the supervisory file.
Interesting. Do you think a supervisory file is disclosable as part of a proceeding for an appeal under the Peace Officers Bill of Rights?
It may or may not be.
Okay. That's all I have.
Stay redirected.
No, I just would like to make a record that the city was never asked to produce Chief Slavin's personnel file, and that would have to be reviewed whether it would be disclosable under the law.
I'm sorry, good to see the appellants never asked that Chief Slavin's personnel file be produced, and whether or not there's a record there.
Correct. That was never requested to be disclosed for this proceeding.
Well, I guess we're going to have the chief, Bell testifies, so we'll find out.
He can and we'll talk about it. I just,
Okay, that's fine.
for the record, for the reviewing court, I'm making a record.
Anything further? I have nothing further. Thank you.
Thank
I
you.
just asked you, thank you very much for taking all this time today. We've given an admonition to all the witnesses that may not talk about the rule. It's been disclosed, that may not talk to anyone because this has been broadcast. There may be people who talk to you about it, who may not talk to someone else. So we've scheduled this through to Tuesday, so at least until Tuesday, or we will not extend beyond that. Do not speak to anyone about your testimony.
Just be safely till after Thanksgiving.
Well,
I don't even want that.
Thank you. Renee.
Thank you.
Anything further before we break for lunch?
No, thank
Okay,
you.
yesterday we spent about an hour or so for lunch. What I'm going to do today is let's go